And Larry, I'll let you go ahead and introduce yourself while Cody's pulling up the slides.
Okay. Good morning or good afternoon, depending upon where you're located in the country. I'm Larry Gendler. I appreciate you joining us today. I was very lucky. I was a juvenile court judge in Sarpy County, which is a suburban county in Omaha, for 28 and a half years. Before that, I was in the county attorney's office. My bio will be part of the stuff that you can receive that you can look at later, so I'm not going to go over it in great detail. But I was really fortunate to work with a lot of really wonderful people, and we embarked on a few projects that helped us, and I'm hoping maybe some of the things that we did might help you. But I would also note there's many things that you do that I'm sure make a difference that we would learn from as well in our system. Is Kurt joined us yet, or should I want me to just keep going?
I don't believe he has. So I'm gonna let Larry go ahead. Our other presenter hasn't been able to join, so he is the county attorney in Albany County, so I don't know if something has come up, but we'll just kind of roll forward with Judge Gendler, and then hopefully Kurt will be able to join us.
All right. Do you want to go to the through the eyes of the child, that first slide? We'll start there. We don't need that. The next one. Okay. So one thing that I learned quickly when I was involved in this project is folks that reside in rural areas do a much better job of collaborating than folks in the urban areas. And I know a lot of you work in areas that are resource deserts compared to larger cities. And congratulations to all of you for the efforts that you make, because I learned quite a bit from meeting and working with folks in rural parts of Nebraska. In 2006, we received a grant and we patterned ourselves after a couple counties in Minnesota to establish teams across the state to work on different issues that they thought were important in their communities related to abuse neglect cases, and then also juvenile justice cases. So when we first met, we met at a large hotel. We had 25 judge-led teams that were identified in advance, and those teams included prosecution, public defenders, probation, health and human services. We had some school component, but that became expanded much later. And as part of that process, we met individually, but we also met in large sessions to hear from others who worked on collaboration in their states. And the goal was to try and come up with a way that folks in those jurisdictions could communicate with each other, learn from each other, and kind of remove the mystique of court and judges, because we're no different than anybody else. We don't have all the answers, and we need help to get those answers. And one of the things that we focused on as part of that initial meeting was how could we front load services? So as it applies to juvenile justice, can we get evaluations done in advance if those cases come to court? What evaluations do we need? And I'll just step back and say, from our perspective and mine, I didn't want us to send a youngster to somebody for an evaluation unless we knew what we were looking for. Otherwise, it's like sending somebody to a doctor and saying, find something wrong with this person. It can be very intrusive and very expensive, and you don't necessarily get the result you want. So we would frequently try and get folks involved with therapeutic services initially, and then from that process determine what, if any, evaluations we needed. We tried to use in-home therapy when we could to lessen the disruptions to the family. We did trauma screenings. Jenny was really helpful with that. She presented to us several times on that. Because we all know what happened to somebody is really important in deciding how to approach and help them and their family. Schools became a really important part of our teams across the state, and I'll talk later about some of the information that we gathered from schools in determining what to do. But I learned an awful lot about IEP and 504 plans through this process. And the other thing that we discussed during this initial meeting was what cases needed to proceed to adjudication, and were there cases that we could determine be removed from that process, or at least put on hold in the court process while they worked on these issues voluntarily. We had about 400 people at this initial meeting. And within a couple of months, all the teams were up and running. And they're still running today. And in fact, they meet once every year at 4 different sites. And then every 3 years, they all meet together at one site. Could you do the next slide, please? So I mentioned some of this here. Calendaring cases was really important. We know that a lot of parents are on a time clock. So we tried to calendar cases to avoid some of those disruptions. Like all of you, we learned a lot from COVID. Zoom became a valuable tool for us. So an example, Sarpy County, where I was working, we had half a dozen school districts roughly. And they would always make sure they set aside a private room if we were conducting a hearing by Zoom for the student. So that allowed the student to stay in school, allowed the parents sometimes could stay at work or be involved in the hearing while sitting in their car. Now, these were hearings that were reviews that didn't require a lot of evidence submission. Those kinds of hearings that were more contested, we wanted to do those in person. But we found that people really appreciated the option of being able to do some of these quick reviews and avoid having to come to the courthouse. And I guess I have to step back and say, if you can avoid the courthouse, that's great, because nobody thinks it's fun going to the courthouse. And for a lot of folks, nothing fun ever happens at the courthouse. And for a lot of folks, they are aware of family members or friends who've been mistreated by the system. And they're scared, they're apprehensive, they're not sure what to expect. So we always tried to give people a chance to voice some concerns during court hearings. But we're all accustomed to this sort of thing, but a lot of these folks are not. So anything that we could do to kind of alleviate that anxiety and get them more engaged, we found very helpful. We appointed counsel before any hearing occurred. If it turned out that the parents could afford counsel at a later date, we would change that. One of the things that always concerned me was I didn't want a lawyer driven by the parent. I didn't want a parent telling a youngster they had to plead or admit to something, or telling a youngster you can't plead to anything. And I also wanted that youngster to be able to talk to that attorney privately about what may be going on in the home, because sometimes there were issues that needed to be addressed and the minor needed a private person to talk to, knowing that information wouldn't get revealed anywhere else. We always tried to craft our court orders to be clear and understandable to everybody. Nebraska has a system called docket, and I'm sure a lot of states have something similar to that, where a judge can generate orders right from the bench. The problem with those, there were no paragraphs, or no page breaks. It was difficult for people to understand, and it's difficult, quite frankly, for even lawyers to understand, because they just were not very easy to read. And I always wanted to make sure that folks understood what was going on, like what our expectations were. And I would often ask youngsters after we were done with the formal part of the hearing if they understood, and the parents. And I'd ask the youngsters to repeat back what were some of the things that we discussed that we want you to do. And the other thing that we talked about in these large meetings when we first met as teams, you can't expect people to do everything all at once. So you wanted to make sure that you identified those things that needed to be done first and other things that could be addressed later, because you don't want to overload folks either. And then on that last piece, whenever we did Zoom hearings, we did breakout rooms where people could visit confidentially about things, particularly the attorney and the youngster. Next slide, please. So the safe and secure housing thing, I wish I had known more about the data on this when I was actually working. I retired about 4 years ago. Jenny and I, with a couple others, we were at a conference in DC, and there was a presentation by Trenton, New Jersey on safe and secure housing. And what they did on every juvenile court case was, before determining what to do, before assessing the needs, the first question they asked were or the minor and parents in safe and secure housing. And if they were not, they would try to address that first. Now, most of these cases involved child welfare, some were overlaps, crossover youth. But the interesting thing was 2 years out, 97% of the people were still living in that housing and doing well. So that was a key indicator to us who attended that safe and secure housing can dictate much of our success. The other question that we discussed, and this came to me through a friend of mine, I asked him, all his friends went to the penitentiary except him, and I asked him what kept him out. And he said it was a gentleman handing out gym towels at the boys club. So the one thing that I always asked myself when I looked at these cases is who in this youngster's life is handing them the gym towel? And if they don't have somebody, we got to find somebody. Maybe it's a teacher, maybe it's a coach. In small towns, it's easier to locate somebody like that because relationships are key for collaboration in those areas. Maybe there's relatives. But I always wanted somebody in that youngster's life who could be that person. The non-custodial parent, frequently they were ignored or unknown to the system. And we found out that once we contacted them, they were willing to participate. Understandably, there may be issues between the non-custodial and custodial parent, and we had to be careful of that. But we found out that a lot of non-custodial parents would willingly become involved if we included them and got them into the court system. Even if they didn't live in our state, just including them by Zoom, including them in therapy, including them in planning, all of that made a difference for the youngster. The societal needs, again, that's cultural in nature. You just want to make sure that youngsters feel comfortable with those they're working with. There's a lot of data out there, I'm sure a lot of you are aware of it, that show that if youngsters are allowed to talk about their history, if parents are allowed to talk about their history, it doesn't matter who the clinician is, the results are much better. Even if there are cultural differences between the clinician and the client, because the client's given an opportunity to speak. So we wanted to make sure that that occurred. Sibling visits were really important for us, particularly if youngsters were placed outside of the home. I was fortunate that we had a lot of resources that prevented placement outside the home. I know that's not always the case. A lot of resentment can occur when that happens. Youngsters feel like that their family's being punished for something they did, and they missed that contact. So we always tried to make sure that there was sibling contact and how it was to occur. Again, I'll mention this out-of-home placement again. It's really difficult, particularly when you send youngsters far away. When you bring them back, it becomes hard to integrate them back into the home with the things they've learned, unless those folks in the home have been part of that rehabilitation process. And when they're 500 miles away, that's really difficult. So we tried to use specialized foster homes when possible, keep them in the area, and try and engage the family in the process. And then with disposition, like anything else, we wanted to try and do things as quickly as possible, but not rushed. If we needed more information, we needed to wait. But 30 days for a youngster from the time they come to court and enter admission, for example, to the disposition, 30 days is a long time. They're wondering for 30 days what's going to happen. So we tried to get that done within 30 days. Sometimes we could try and go to immediate disposition after the plea, for example, if we had evaluations or resources or other things in place because we had front loaded the system. Go to the next slide. Next slide, please. I think this is kind of important. Judges clearly don't have all the information. We're only as effective as what we know, and that's what's presented to us. Probation doesn't always have all the information. Parents don't always have all the information. The minor, I frequently will not understand the recommendations because they're nervous. Sometimes courts will leave open-ended dates. For example, in Nebraska, you're not an adult until you're 19. So youngsters will come into court and they're 16 years old. Does this mean they have to be in court till they're 19? That's something that we try to avoid. And I think we had some success with that. Forgive me for a minute here. Something got messed up on my Zoom. We go to the next slide, please.
Yes, also your co-presenter is here. Kurt, you
Oh,
can go
terrific.
ahead and turn on video and unmute yourself and join the presentation.
I should be unmuted and my video should be on.
Amazing.
I'm going to go to this next thing is part of reflective practice, and I have to credit Jenny and some others for this. We were trained in reflective practice, we meaning a few judges, which is a way to handle feelings and frustrations with different issues. So I'm just going to talk about this briefly because the training really takes a couple of days. But I use this a lot in the courtroom, and the idea was to meet folks where they're at. Here's an easy example. We have a parent who was frustrated because the recommendation of a clinician was that their child participate in outpatient treatment. And they would say their kids doesn't have an addiction issue. They haven't even seen the evaluation. They've just been told about it. So we would talk about that. Maybe I'd continue the hearing so they'd have a chance to visit with the clinician. If they'd already read the evaluation and still have concerns, we would talk about what those concerns were. Always tried to keep the environment calm because nothing productive happens out of anger in a courtroom. And then we would give them, the parents particularly, a chance to reflect on what others were recommending and why. And we might end up where we're at the end of the stage there where we're reflecting on what has been discussed, and maybe we agree on something short term, but we come back. So for example, in that case, I might say, well, listen, maybe you're right. Let's come back in 2 months. And in the meantime, we're going to randomly test your youngster. We'll engage with these other recommendations and see if these things are working. And if we don't have any further concerns, then we don't have to do the treatment. Or the same issue might apply if we wanted the youngster to be in drug court and the parents were against that. And so what I liked about reflective practice was it kind of conceptualized what we were all trying to do, but it wasn't ever put on paper, so to speak. And that is the idea that we give people a chance to express their feelings, their concerns, give them a chance to think about what some of the options are, and then from there coming up with a solution that everybody can live with, at least temporarily. And we found that giving the folks this option really improved engagement. They were more likely to understand when recommendations were being made that were different than what were initially approached with. When they came back to court, they'd understand why we needed to do the treatment, for example, or drug court, for example. And they felt like they were part of the process. This chart that I'm showing here is regarding to a baby. So when this process was first developed, like for example, if a parent didn't want their children to get vaccinated, we actually had a case like that in our court. They would meet with the pediatrician, and the pediatrician would meet them where they're at with their feelings and come up with a solution. Maybe we do one vaccination and come back in 2 months and do another vaccination, so we can see what kind of reactions there were to it. But I'm a big believer in this model and think that anybody that can get trained in it will be more effective in working with folks, whether you're a judge, a caseworker, a probation officer. It's just a way to calm the waters and get people to discuss concerns and coming up with solutions that folks can live with, and them engaging in the process and really supporting the process. So as a result, I think we found parents to be much more supportive of our efforts. And I think the youngsters involved in court felt like they were heard, even though we disagreed with what they wanted. We go to the next slide. So we came up with something called an education court report form. I can get that to any of you if you'd like it. It's roughly 5 pages. And this was a way for us to engage with the school districts and make them really an important part of our process. So the report itself was filled out by a probation officer or a caseworker, but it was filled out in discussions with a school counselor or a school representative. And some of the things we wanted to know, for example, is where they're enrolled and if they're attending. And if there are truancy issues, we want to know what those are. We also wanted to know who had educational rights. Sometimes it was only one parent, not both. And if it was only one parent, how do we get the other parent educated on the status of their youngster's school performance? Extracurricular activities were also important. And as part of that, we wanted to know if the folks could afford those activities. And if they could not, what ways could we think about supporting some of that? We were lucky because we had a CASA program in our county, and their office was right around the corner from our office. And they did fundraising and would frequently support activities so youngsters could participate in soccer or baseball, band. We actually had a CASA who donated a guitar to a youngster who wanted to take guitar lessons in our court system. So that we thought that was pretty important. The IEPs and the 504 plans were critically important. And we discovered that sometimes schools didn't have the information that the court system had on the needs of the youngster, or the court system didn't have what the needs were from the school's perspective for the youngster. And sometimes the attorneys would attend those meetings with the school district or the guardian ad litem, and we found that very helpful. I've talked about attendance. Transportation was another issue, and that's always going to be an issue with these families, I think. Sometimes they have vehicles that break down. They're not on the bus route. So we had the schools assist us with those issues. Health issues and unaddressed disabilities were critically important. We wanted to make sure that all of us were aware of any issues involving disabilities that were occurring in the school that they had observed or knew about. And also health issues, including health issues in the home. We had, and I'm sure all of you are aware, and have had parents who are struggling with health issues. So we always wanted to make sure that we could be a support for that as well in some way. And then, of course, the issue of suspensions and expulsions. Did those occur? How frequently? Any of the reasons for that? So this was all contained. It was a snapshot. And the goal was to, if there are any red flags, that people could explore further what was behind those red flags and what we could do as a system to address that. Can I get the next slide, please? So that we have also called what was called the Youth Court Questionnaire, and this is another 4 or 5 page document. And this is what the youth filled out, particularly those youth that were placed outside of the home. And we wanted to hear from their perspective. How do you feel where you're living? Do you understand what the plan is? Is there an independent living plan if you're not going back home? The sibling visitation issue, any dental or medical issues. I should have added their eyeglasses because that was something that was important. Therapy, medication, the activities that we talked about, if they're working. We want to know what professionals had contact with them and the frequency of that. That also included family members. What was critical, as I've mentioned before, is they understand what the plan was. We wanted to make sure, particularly for those older youngsters, that they were able to read all those reports and understood what was recommended. We didn't want to keep secrets from these kids, particularly the older ones who trust is, I guess that's what it boils down to for me. That's the big word. You want people to trust the system. So we felt all of this helped. Can I go to the next slide? So if a youngster was placed outside of the home, we had a caregiver questionnaire. We want to know if they were related to the minor. We always wanted pictures, fun stuff. If they're involved in sports, soccer, baseball, a picture of them doing that. We want to know from their perspective the physical and medical condition of the child, educational status, emotional status, the unmet needs from their perspective, what professionals have been in contact with them since the last court hearing, what visits have occurred with whom and when. And on those rare occasions, if we needed to consider permanency, was this an option? I go to the next slide. So this is the last slide, and I know this is something that all of you have been made aware of. Re-entry was really an important part of the process for us. What did it look like? So at the end of the spectrum, the far left there, if we've got somebody placed outside of the home, that next part of that circle, reintegration, was really important. And we didn't want youngsters to come back and then fall back into the system and start all over again. That's not good for anybody. So a lot of planning by a lot of other folks went into place. So when those youngsters were released, things were in place. And those things included extracurricular activities. They included contact with relatives and others who were important. They included that person who may have been the gym towel person before they were sent away. All of that was important to us and made a difference. So that's where I'm going to end here and let Kurt begin. And if you have questions, we can go over those in the breakout rooms. But more importantly, if you have questions, my email address will be on the PowerPoint. Please feel free to email me if you have questions or comments. And again, I just want to highlight, I appreciate all of you do, because all of you do make a difference. You're never told that enough.
Thanks. Kurt, I'll let you introduce yourself, and then you can talk to us about Albany County's single point of entry. And then after that, we'll be sending you guys to breakout rooms. You can choose, if you're thinking about from a prosecutor perspective, how you want to get those folks involved, to go with Kurt. Or if you, need to work on your continuum work with a judge, you can go with Larry to his breakout room. But we'll let Kurt do his presentation, and then we'll head to breakout rooms in a little bit.
Thanks, Jenny. Sorry I was late. I was noon my time, which is probably for the rest of you 10 o'clock. Or it is noon now. It's 10:30 for me. So I came out to Wyoming to go to law school. Laramie is the home of the University of Wyoming. I stayed here, and then after a couple of years of private practice, went into the prosecution here at the Albany County Attorney's Office, and now the Albany County Attorney. I mainly have done adult prosecution, but for a couple of years we did not have a juvenile prosecutor, and I covered the juvenile prosecution realm, and I actually found that very instructive. And my predecessor had set up some excellent systems in our jurisdiction, with the goal being to keep kids out of the court system, to keep them from having any sort of record. And Wyoming set up what's called the single point of entry system, which you can move on to the next slide. Single point of entry was set up statutorily. It mandates that all citations or police reports or anything that's going to lead to a criminal charge first goes to the district attorney in the jurisdiction. So it bypasses citations going to courts, or things just getting filed with the courts to prevent any sort of record being started by the juvenile. We set up a single point of entry team, including schools, Department of Family Services, counselors in the community, basically people that had contact with the juveniles that we might be discussing. Every week, Big Brothers Big Sisters, they have an employee there. They also run our diversion program, who sends out basically a compilation on the juvenile in question. And then we go over each juvenile, people that have had interactions with the family or with the juvenile, him or herself, can then give recommendations, with the goal being trying to give the family and the juvenile services without actually having to file in juvenile or adult court. You can go on to the next slide. Okay, so all law enforcement contacts they're forwarded to my office. Generally, we get either citations or police reports forwarded on. We put everything together. We will meet on them if they're more serious. So if they're extremely violent or if they involve a sex crime, then we will review those just in my office, and we'll make charging decisions from there. It is a small town. I mean, we try to keep the more violent and more personal crimes not going to single point of entry. These are few and far between, but we really try to curtail them off. Generally, they're going to go to juvenile court anyway, so we just go ahead and vet them ourselves. And if need be, we get those matters filed in juvenile court. If it is a traffic offense, particularly anything short of like hit and run, maybe reckless driving, of course, DUI, those would all go on for review. But failure to maintain a signal lane or speeding, we can just go ahead and offer live at 25 for the first offense, and handle it that way. It allows for us to kind of vet those off without engaging the entire team. If they're adults or any of the other, we have colleges here. We also have the Wyoming Technical Institute. Oftentimes, the kids that are 17 going into the University of Wyoming or to our Wyo Tech, not really meant to go into the diversion program or into our juvenile court. So we'll oftentimes also move them off into a different route. Child protection matters are not covered. We're only talking about juvenile delinquencies here. Child protections are vetted by ourselves and DFS, and generally we'll make decisions as that pertains what's best for the child. Sometimes there's just no action taken. It's a minor offense. We've got the child already wrapped up in services. We just kind of let it go. But most of the non-traffic offenses and non-violent offenses, as far as felony level, go into the single point of entry program. It meets every week at 9 a.m. And like I said, we have DFS, the schools, counselors, our office. We have other institutions in our community. The Cathedral Home for Children is here. I know Nebraska utilizes that institution quite often, but they also have services that can be offered and interactions with the families, so they're a part of it as well. It's quite a large team, and the idea is to collect as much information as possible on these juveniles so we can make the best decision on where to send them in our system. You can move on to the next slide. We have an objective criteria. I've got a copy here. It's been revamped many times. We have the Wyoming's Children's Centers located here in Laramie. The idea with the objective criteria was to make it fact-based, to remove any biases we might have or might be kind of built in to reviewing these cases. It is a very small community. We are familiar with families. I'm sure it's similar in your jurisdictions, where you see a family name and everyone's antennas go up. We wanted to the best we could remove those implicit biases, and just come up with a way we could look at the kid and just see what the child needed, not where he came from, not who he associated with, and not have that overly influence us. It does come into play as far as familiar support, because we will know that the family has not historically engaged. Are there troubles at home? Are there drug use at home? Which is very common. But the objective criteria are trying to weed that out as much as possible, and just make the analysis and the discussion about the child itself or herself or himself. So we get the name of the child, the age of the child, if we can get them the parents' names as well, guardians if they're staying with a guardian, a grandparent, or a family friend or aunt and uncle, current offenses that they're currently facing, any prior history they have with the criminal justice system, whether that was charged or uncharged, just law enforcement contacts in general. Very important to us, as we saw off Larry's slides, he had the educational snapshot. We basically get that for our kids as they're coming through the single point of entry, which we always put a lot of weight on. Grades, where they are in their studies. Truancy is a huge issue. We also often see grades and truancy are connected, and it often goes along with behavioral familiar supports. And the school district here, we have a lot of resources with our school district. If transportation is an issue, the school district will provide transportation. They can provide extra counseling. They have tobacco cessation programs. They will go really above and beyond with these kids. But by having the school district there at these meetings, they're able to give us a rundown of what they've done in the past and what they're able to do in the future. So when we're examining whether or not to send a kid through the system or to maybe try some more community supports or diversion with some more school supports, we can actually help the child in that regard. We also get to have the privy to the knowledge of any disabilities they may have. If they're on IEP, maybe that's something they need that they haven't been provided yet. Something we could provide for them short of actually filing and getting them into court. The goal of this entire system really is to keep kids out of the criminal and juvenile justice system, to keep them out of in front of a judge, and try to help them and their families the best they can. So all of this comes together, and it really does give my office a better idea on how to best serve these families and these kids. I mean, when we see a name come in, particularly if we've not dealt with the family of the child before, we don't know anything about the child. And what I've often found is even if it's a minor offense, they've just managed to stay off the radar, and they may need like a higher level of support. Doesn't necessarily mean we're going to file them into the juvenile justice system, but maybe we need DFS more involved. Maybe they need a case plan. Maybe we need more school supports. We need some monitoring of the child, get these services together. We have, for the older kids, the Cathedral Home for Children, they have basically an adult living class where if the kids are getting older, they can help give them life skills, where we can help start getting them set up with getting a place to live, knowing how to pay bills, getting employment, and they can link up with the school has a vocational program. We've gotten kids vocational training while also getting their GED, and then they're able to go out and actually have a job where they're making a livable wage. And with the help of all these systems, we can keep them out of the system and keep them out of filing, but we can also, to the most we can, best we can, set them up for success so these kids just aren't going out, turning 18, and hanging out with friends and getting into more trouble. You can move on to the next slide. We get all their current and past services they've had as far as the family and the youth. That's a list basically of what we have here. We have wraparound services with the Cathedral Home. We can get them counseling. The Laramie Youth Crisis Centers is a facility we have here. It's a short-term place we can put kids that can't stay at home, that need somewhere to go, basically a break from the family, get them away, give them a cooling down period without trying to take them into protective custody or somehow interfere with the way their family is set up at that point. You can go ahead to the next slide. So this is a rundown of who we have in the single point of entry team. Big Brothers Big Sisters is in Wyoming, and particularly in Albany County, a very large part of what we have for juveniles. We are rural. We're on the poorer side. We don't have a lot of services. There's only 500,000 people in the state. There's only 30,000 in Albany County, and Albany County is almost the size of the state of Connecticut, so it's huge geographically, but we have very, very few residents, and they're almost all here in Laramie. So our big non-governmental agency that can help us out and really provides most of the services in town is Big Brothers Big Sisters. They run through our CGSB grant, our diversion program. They set up the SPE meeting team. They put together the compilation of information on the juvenile, and they really are key to the system we have set up. Of course, the Department of Family Services, you may have DHS or however you call it in your jurisdiction. The school district, law enforcement weighs in, but not a lot. We have an SRO, a school resource officer program, they have minimal contact with the students, but the school district has really worked to keep that kind of interaction as low as possible. So law enforcement does a fairly minimal amount with our juveniles. We, of course, have our other big partners at the Laramie Youth Crisis Center, which is run by the Cathedral Home for Children. And finally, is the Volunteers of America. They provide the most help for our adults in our community as far as mental health, substance abuse, housing, that sort of thing. I'm sure in every jurisdiction, as Larry was saying, the big needs, the big problems for these families are housing, transportation, and finding employment that provides a livable wage. Often they're dealing with mental health issues, just lack of support in the home, and substances, particularly here is methamphetamine, unfortunately play a very large role, particularly with our child protection cases. They really drive those cases. And oftentimes there's a lot of overlap, of course, with the kids that are getting delinquency petitions filed against them and the families that are getting child protection cases filed on them. Same families are often involved. Not always, but often there is a good deal of overlap. Big Brothers Big Sisters runs our diversion program. I don't know how we would function here without it. That keeps our kids out of the criminal justice system. For the most part, I bet 80 to 90% of our kids who go through SPOE or single point of entry end up getting diversion. You can go to the next slide. Diversion is basically three-layered. It is either low, medium, or high, depending on the youth's need, prior contacts, if they've been in diversion or are in diversion at that time. Diversion basically is it's a contract. We send letters out inviting parents to enter in the diversion program or have their children enter into the diversion program. There's also a contract they sign with Big Brothers Big Sisters. They're invited to speak with an attorney, and we assist them with that if they would like, because these, of course, are criminal charges. The only time a child is put through the SPOE process is if they've committed a juvenile delinquent act, which would be an act that was criminal if they were an adult. So they do have rights, and we try to cover those by offering them the assistance of an attorney if they would like to speak to one. If they do decide to sign up, we get them signed up. There is a fee, but we oftentimes waive that fee. It's nominal, but for these families, I believe it was $60. It can be high. We've basically gotten rid of that at that point. The waiver's the default position at this point. And they go through Big Brothers Big Sisters. They have an interview. They figure out from the parents or the guardians what this child is really struggling. You know, is it school? Is it getting to school? Is it often it's their peer group they're hanging out with, or a combination thereof that's getting them into trouble. They have an old school south side of town which they've redone into Big Brothers Big Sisters institution. It's very well set out. They have computer rooms and music rooms, lots of activities for the kids. They provide music lessons and activities. They have the usual standard Big Brothers Big Sisters program they can engage in, where members of the community will, take these kids under their wing and take them out in the community and try to mentor and foster them. They have a full-time staff. They can provide substance abuse and mental health counseling, both of which can be hard to get outside of one of these organizations in our community. So it really is, it's a great program. They provide after-school assistantship. They'll help tutor the kids if they're having trouble in class, make sure they do their homework. It's basically a place for the kids that are in the diversion program and otherwise, somewhere they can go, basically an after-school program as well. In our community, it's the only program we have like that, so they serve a lot of different populations. But for the diversion program, we find it works well. They get to connect with the counselors and the people that are working there. They do a very good job of engaging with the families. I think, and they have a much better success rate engaging with the families oftentimes than we would have if we brought them into court. Court for one is adversarial. They would have a defense attorney. They may have a GAL in a delinquency matter, not always in our jurisdiction. We have to ask for one. And then they would have DFS and the state. As you know, the court process, at least in my experience here in Albany County, it is not nearly as engaging. You are dealing with DFS, and I think, well, I know parents, there is some aversion to engaging with DFS. I mean, it is known that these are the folks that will take your kids, you know, if you're not raising them in a way the state feels is appropriate. So there is, thank you. There is really an aversion when we get them in the court system to actually engaging with the children. And diversion is much less threatening. They don't go to court. There's no record. We have the police reports and citations in my office. If they successfully complete, we just simply shred them. So there is nothing that comes up after that. And it really is, it has been very successful as far as recidivism rates. And it keeps the court numbers way down. And keeps our interactions with the juveniles to the bare minimum, which is really our goal. Juvenile court is one option as we're going through this single point of entry process. The options really are no action, adult court, diversion, or juvenile court. Juvenile court really is for either very serious offense or for a kid who really needs to be in the system. They have failed entirely at school. They're not going. Their family may have just raised their hands up. They don't know what to do. Oftentimes, you're talking 14, 15-year-olds who are simply refusing to go to school, even if the school comes to pick them up. And then they're also engaging in criminal conduct. And we're really just at the point where we need that higher level. And the school and DFS and diversion just aren't able to meet them at their need level. And we can send them into juvenile court. In Albany County, we have a juvenile drug court program, which brings in a lot of resources. It is federally funded, and it provides much higher levels of counseling and assistance than we can provide just from our community. It's been a great resource with providing counseling. I'm sure it's similar in your jurisdictions, though it may vary with the size. We just simply don't have many counselors here in Albany County. They are very hard to get. They don't particularly want to live in this rural of a jurisdiction. And the weather's rather harsh here as well, so it can be hard to get people here. And we just have found the remote counseling just doesn't work to the same level as having face-to-face. The juvenile drug court program has allowed us to contract with providers and get providers to come to this community that will provide that face-to-face counseling. And the kids have really engaged with that. It's been very good with that. We recently lost our peer treatment individual, but she was outstanding in engaging with the families and the kids and really connecting with them and getting them to engage and buy into the program, which you really need for them to be successful. But court is not our goal with single point of entry, but it is an option and a tool. Sometimes we have to file into court, and it's the only way to get the juvenile what they need, or they engage in violent conduct that we really don't have any control over. You can go to the next slide. So when we're doing that initial assessment in the single point of entry program, the school has provided all the school background information. DFS has provided all the prior contacts with the juvenile and the family. And we've heard from our local institutions in my office, any interactions we may have with the family or the juvenile in question. Sometimes we need to follow up through our juvenile drug court, our juvenile court drug court program. We can get substance abuse assessments conducted prior to making the decision whether to file into court or to offer the diversion program to better assist, where they are. It is voluntary. It's something we offer the families. And oftentimes the families, they know their child has a substance abuse problem, I'm sorry. And they are more than happy to have their kid take substance abuse assessment, get the results back, and it better helps us to decide where these kids need to be. We had a big problem when we were starting this and meeting kids, at their need level. And the problem we were running into is we were putting kids in, if you just start at the bottom, unless it was one of those very severe crimes, you would just start at the bottom. And then, as you failed, we would ratchet you up until finally we filed you into juvenile court. And then we would maybe up you to the drug court program. And then, at least with a couple of the kids, we had to send them off to our girls or boys school, depending, which is our highest level here in Wyoming for delinquents. And so we came up with this idea to try to meet the kids better where their needs are at the time. We're trying to do that across the spectrum, because what we found was we were keeping these kids in the system, for one thing, for an extended period of time, which is not good. And by the time, if we would have gotten them the treatment they needed at the front end, we could avoid perhaps sending them off to a more restrictive placement at the end, because we'd simply run out of options. So we do offer the substance abuse treatment assessments, or substance abuse assessments earlier on, both in SPOE, and then once we get them in, if we file on them, get them in to the juvenile court system. The one issue we really ran into with the diversion program was restitution. If they committed a lot of property damage, or if they had stolen a lot of property or money, facilitating the repayment of the money that was owed is problematic. Generally, that would be in Wyoming a court-driven system in which you're ordered by a judge to pay through the clerk of court restitution in a certain amount to a certain victim. And we really struggled with how to facilitate that and what to do if they didn't pay. It's hard even in court because they are kids when we're talking about restitution. But it was important for us we have some sort of responsibility as far as making victims whole. I think it's good for the juvenile, and we need to watch out for victims' rights as well. I mean, oftentimes these kids would cause significant amount of damage, slashing tires, breaking windows at local businesses, or whatever it may be. So it's something we're still wrestling with. If it's high restitution, we found really the only way to facilitate it is to file in a juvenile court. It really just becomes too burdensome. And you don't want to be left at the point where you have a juvenile who's done everything you would like, except for pay the $500 in restitution. And then, I mean, do you send them through juvenile court at that point? It's not really point of the juvenile court, but it's just not a very effective way to do things. You can switch to the next slide. Well, that may be it. I didn't put my contact information on here, but you're welcome to have it. Jenny has it. Reach out if you'd like to know more about our program or our objective criteria. I'm happy to share a talk. But thank you all for coming. Thank you for everything you do. And I'll turn it over to Jenny.
Yes, thanks, Kurt. Yeah, and Kurt, Albany County is one of the Continuum of Care grantees. So we appreciate you pitching in today. We have a little bit of time, and Cody is going to help us get into breakout rooms for about 20 minutes, just for you to do a little focused Q&A, either about incorporating the court and judges on board with your continuum of care work, or working with your prosecutor's office. Hey, everybody. Our group has dwindled for the last few minutes. Maybe I was going to say something really fascinating, and now they all missed it because they dropped off. So just wanted to thank our presenters and thank you guys for thinking together This is kind of the point where I remind you all that if you want more peer time, like Kurt is a peer of yours. So if you had this and you're like, I want to talk through this some more, we can always, as your TA providers, facilitate that kind of discussion or, find a way for you guys to get together. And if you want any technical assistance around any of this. So Larry's on our expert advisory panel. So we have access for him as a subject matter expert, to talk to, your team or, have a discussion with your judges and things like that. And we have other resources like that. So this doesn't have to be the end of this conversation, but just wondering if anybody had any big takeaways or anything that they wanted to share before we pop off for the rest of our day.
To me and Lydia, I'm curious how this goes after we've discussed your efforts. So if you have other issues or concerns, feel free to email me. I wish you well with what you're trying to accomplish. And Catherine, I'm impressed with what you've accomplished, given what you explained.
Thank you. It definitely will.
Yeah,
Thank you.
absolutely. All right. Well,
Thanks, everybody. That was great.
yeah, thank
Glad to be
you.
here. Nice to
Thanks
see
for
everyone.
everybody putting up with my cat faux pas. So
I thought that was really cute.
in our other breakout room, someone was talking about cats being thrown into an incinerator and being the person not being charged. And Sonny just continued. I said, this is why punishment and threats don't work. He heard cats were incinerated and he tried to knock my computer over. He was like, I don't care. I don't care. So this is why working at home is so much fun. So
And Jenny, I think you have to say either pun intended or no pun intended with the faux pas comment.
oh yes,
So
yes.
Just saying.
I would like to think that that was pun intended, but it was accidental. But yeah. Yeah. Well, it's good to see everybody. Thank you to Larry and Kurt.